the Basel Convention, the Stockholm Convention, and the Rotterdam Convention. Tonight we have a really amazing panel guests on a very interesting topic about shipbreaking as it is conducted today, and two conventions that are vying to control it. My name is Jim Puckett. I'm with the Basel Action Network, one of the sponsors of this side event. And we're going to go through these speakers one by one. We're not going to introduce them all in advance, but as they pop up on the schedule here. And I think you're going to be very intrigued with the program. This is being recorded. If you want to go back and get the summary, getting documents about this issue, and a recording of this presentation, it'll all be there on the Geneva Environmental Network website. So I want to thank the Geneva Environmental Network for this program. And without too much further ado, I'm going to introduce our first speaker. We're honored to have Marcos Orellana, who is the UN Special Rapporteur on Toxics and Human Rights. Marcos is going to give us some opening remarks about what we're all going to be listening to today.
Thank you, Jim. I'm really pleased to have the opportunity to be with you this evening. My name is Marcos Orellana. I'm the United Nations Special Rapporteur on Toxics and Human Rights. This is a special procedure of the UN Human Rights Council that has been created in the understanding that exposure to hazardous substances or wastes can lead to a range of negative interferences with internationally protected human rights. One of my predecessors in this mandate did a dedicated thematic report on shipbreaking, and it found that ship recycling, ship dismantling, or shipbreaking, as it's known, is one of the largest sources and transfers of hazardous waste from the global north to the global south. He also pointed out that shipbreaking had attracted international notoriety because of the working conditions leading to deaths and illnesses of workers, as well as pollution released. I have echoed these concerns in my report on my official visit to the International Maritime Organization that I presented to the Human Rights Council a couple of years ago, pointing out that this is not only a local pollution issue. Certainly the beaches in Bangladesh and India and the coasts in Turkey and elsewhere are being polluted. But it is well known that some of the pollutants released are capable of long-range transport and persistence. So it does pose global environmental issues and global environmental justice issues, as certain developing countries do not want to be seen as the dumping ground of the global economy. This is an issue involving toxic colonialism. Racialized undertones cannot be ignored. This is the first point I thought I'd make. A second point is on treaty parallels. I made this point earlier in the week. With the entry into force of the Hong Kong Convention in June of this year, we will have two treaties directly dealing with the subject matter, because as the Basel Convention has resolved, a ship may become a waste under the Basel Convention and remain a ship under other rules of international law. And so we have dual layers of protection. Now, this is not uncommon. We look at the recent advisory opinion of the International Tribunal for the Law of the Sea, for example, on issues of climate change. It very clearly pointed out that we have the UN Convention on the Law of the Sea, on the one hand, establishing distinct obligation, and on the other, international treaties concerning climate change. And so the Paris Agreement does not eclipse or displace the UN Convention on the Law of the Sea. Similarly, by analogy, we have in Basel, Rotterdam, and Stockholm Conventions establishing international obligations, and at the same time, we have international human rights treaties establishing international obligations. So the Basel Convention and the Hong Kong Convention coexist. What are some of the implications of treaty parallelism? that conflict, first of all, is not to be presumed. And second of all, the general principles for resolving conflict, they only avail if there are no savings clauses in the treaties that govern the way that a treaty relates to another treaty. And that is precisely the situation in connection with the Hong Kong Convention and the Basel Convention. There's a savings clause in the Hong Kong Convention that expresses that it is without prejudice to other international obligations. Let's recall clearly the Hong Kong Convention was negotiated after Basel, so this savings clause implicitly affirms the primacy of the Basel Convention. And similarly, there's a savings clause in the Basel Convention. It is well known that Article 11 of the Basel Convention allows for transboundary movements of hazardous wastes in agreements that offer equivalent levels of protection and control. This raises the question whether the Hong Kong Convention offers a protection that is equivalent to Basel. I had the opportunity to speak before the Marine Environment Protection Committee of the International Maritime Organization last year, analyzing this question and making the point that there's no equivalence in the levels of control or protection offered by the Hong Kong Convention as compared with Basel. I won't elaborate now since I understand other speakers will address that. And since I'm arriving towards the end of my time, the third point I wish to make is that recognition at the international level of the right to a clean, healthy, and sustainable environment imposes challenges on these instruments. Recognition by the UN General Assembly. Also, the International Labour Organization has recognized the right to a healthy environment as a fundamental principle and right at work. In my report to the Human Rights Council on my visit to the International Maritime Organization, I recommend an amendment of the Hong Kong Convention to bring it into line in light of recognition of the right to a healthy environment, so that it establishes mandatory standards such as decontamination of vessels before they're taken for ship recycling to the fullest extent possible, or the containment of facilities, because at this time, the Hong Kong Convention allows for the practice of beaching that releases pollutants to the marine environment. Now, there's ample precedent in international law with amendments of conventions. We don't need to look too far to see that the Basel Convention has been amended multiple times. A significant amendment is the Basel Ban Amendment, so-called Basel Ban Amendment, which is a fundamental obligation to prevent the human rights violations that would otherwise occur with the transfer of hazardous wastes to developing countries from the global north, lacking capacities. There's no such ban under the Hong Kong Convention, which presents the risks of circumvention of the Basel Ban Amendment. There's also the need for a strengthening of the Basel Convention, more ratifications of the Basel Ban Amendment. I understand there are 100 plus parties, so more parties are needed, but also clarifications of what is the state of export of the vessel. I'm out of time, so I will only conclude pointing out that shipbreaking, as currently practiced, is a threat and a source of harm to human rights globally. Secondly, that treaty parallelism means that all these treaties coexist and they need to find a way to work together. And thirdly, that the right to a healthy environment imposes the challenge of strengthening these agreements so that this right may be realized. With that, thank you for your attention. Thank you, Jim, for giving me the...
Thank you, Marcos. And next, while we're on the subject of human rights, I have the pleasure to introduce Julia Bleckner from Human Rights Watch, coming from New York, to the meeting here to talk about a report that they've done on the ground recently.
I think we'll actually start with a short video from.
বিশ্বের সবচেয়ে ঝুঁকিপূর্ণ শিল্প হইতেছে শিপ ব্রেকিং শিল্প।
বাবা যে স্পট ডেট হয়েছে এটা দেখে উনি সেন্সলেস হয়ে গেছে, উনি কথাই বলতে পারতেছেন না।
ওই পিছলে পড়ছি মানে আমার ওই গামবুটের তেলের কারণে।
অ্যাসবেস্টসে অনেক শ্রমিক ক্যান্সারে আক্রান্ত হইতেছে।
জানা যে কাজ দিয়েছেন অ্যাসবেস্টস এটা ক্রনিক্যাল ডিজিজ তৈরি করে, সেটা আমাকে বলবেন না?
ক্ষতিকর যে বর্জ্যগুলো আছে এগুলো আমাদের সাগরের পানিতে মিশে।
সরকার জানে এখানে কি অবস্থা হইতেছে, ইউরোপিয়ানরা জানে, মালিকরাও জানে এখানে কি অবস্থা হইতেছে। যদি আমার কণ্ঠরা বুঝতে পারে, সেটা আমার জন্য অনেক ঝুঁকিপূর্ণ হয়ে যাবে। তারপরেও আমি চাই যে শিপব্রেকিং এ পরিবর্তন আসুক, যার কারণে আমি এই কথাগুলো বলতে চাই।
So this clip is from a film that Human Rights Watch produced in 2023 alongside a report documenting the conditions of the shipbreaking industry in Bangladesh. As you can see, shipbreaking workers took great personal risk to share with us the dire conditions of the yards in Bangladesh. We interviewed 45 shipbreaking workers who described a dangerous working environment where toxic waste is dumped directly onto the beach and in the water. Workers consistently said that they're not provided with the adequate protection equipment or tools to safely do their jobs. They described using their socks as gloves to avoid burning their hands as they cut through molten steel, wrapping their shirts around their mouths to avoid inhaling toxic fumes, and carrying chunks of steel while barefoot. They described injuries from falling chunks of steel or being trapped inside a ship when it caught fire or when pipes exploded. Because yards in Bangladesh use the beaching method, in case of an explosion or another accident, workers are often forced to carry their injured coworkers from the beach to the road because emergency vehicles can't reach them on the sand. In Bangladesh, the life expectancy for men in the shipbreaking industry is 20 years lower than the average. Sabir, a 27-year-old shipbreaking worker, told us, "I face risk every day that I work in the shipbreaking yard. Nobody wants to work here because they know there's a risk and accidents may occur at any step." 2 years later, in September 2024, an oil tanker exploded in SN Corporation yard, the same yard that Sabir had been working in, killing 7 workers and injuring 10. Workers desperately carried their colleagues off of the sand to seek care. The tanker had been sold to SN Corporation by a subsidiary of the cash buyer Best Oasis, despite SN Corporation's poor health and safety record, with at least 14 deaths and 22 injuries on record before that sale. Shortly after, the yard was allowed to reopen, after a period of about 3 months of investigations, another accident occurred. The fact that SN Corporation was a Hong Kong Convention certified yard when these accidents took place underscores how inadequate the convention is to ensure genuinely safe and sustainable ship recycling. None of the violations that Human Rights Watch found in the yards in Bangladesh will be remedied by the application of the Hong Kong Convention. Hong Kong compliant yards can continue to break ships on the beach, dump waste in the sea, and sidestep safety precautions. Effective enforcement of the Basel Convention would require exporting countries to ensure that ships are only sent to countries with sufficient capacity for environmentally sustainable management of toxic waste. Instead of investing time and resources in greenwashing unsafe practices, companies should invest in proven ship recycling methods that are off the beach and support the effective application of the Basel.
Thank you very much, Julia. Next, we have Ingvild Jensen, the director of the NGO Shipbreaking Platform. She's going to do a little exercise on what a compliant Hong Kong yard looks like. You all remember the game, What's Wrong with This Picture? We're going to have a stab at that game.
Thank you, Jim, for the floor. My presentation will be from pollution to solution. So we'll go through what a Hong Kong compliant facility actually looks like, but I'll also propose some solutions that are available and actually already. So this is, Julia talked about Bangladesh. I'll focus on India and the beach of Alang. So there are 3 beaches in the world where the vast majority of ships are dismantled, as many of you know. One of them is Alang. It's a beach in the state of Gujarat, about a 10-kilometer long strip of beach, and there are more than 100 facilities plotted one next to the other. Most of these facilities have been able to obtain a statement of compliance with the Hong Kong Convention. So 95% of these facilities have a statement of compliance with the Hong Kong Convention. And I'll be talking a bit about the breaking of the São Vicente, an FSO, at one of these facilities. This brings me to the picture, and if someone wants to raise their hand and identify the problems that you can see on this picture. There are more than 5, so anyone who wants to raise their hand and say one. Here they are. There are many. And this facility, Priya Blue, so it's the breaking of a ship in 2022, so it's not that long ago. Priya Blue is a shipbreaking yard that was one of the first in Alang to obtain a statement of compliance in 2016 from Class NK, Japanese classification society. I'm not putting them in doubt, but I'm putting the standard up against which Class NK is certifying the facility in doubt. Since 2016, this yard has had a statement of compliance, meaning it's only valid for 5 years. So they've actually obtained it twice. So they've been checked twice. They still have it. And as you can see from the picture, there are wastes that are not contained. There are pieces that are being dumped in the water behind. What's important to know is that now you can see the water kind of covering the vessel, but the tide here is massive, so it will go way back and you will have workers. And with that tide, a lot of this pollution will be following. And this facility is Hong Kong compliant. The one next to it is Hong Kong compliant. And all the many hazardous materials that are in the paints of the ship, in the structures of the ship, are falling into uncontained areas and being brought to the sea, polluting the groundwaters, etc. So this is a Hong Kong compliant facility, and I think this does not comply with what the Basel parties have defined as safe and environmentally sound. What belongs to this story as well is that this was a ship owned by a Norwegian company, BV Offshore. The breaking of this vessel was being monitored by a consultancy, a Norwegian consultancy, Greg Green. So there were enough people here to kind of look at what was going on, to identify if there was something wrong. And what also belongs to the story is that there was a fatal accident at this yard, but we only found out about it because there was a German journalist that happened to be in the area at the time. So we reached out to BV Offshore, the company, and informed them about the fatal accident. And what did they do? They said, well, it's not our responsibility, and it didn't happen on our ship. There's only one ship at this yard. The one you can see in front is a barge used to lift pieces. There was an explosion of a nitrogen tank that killed the worker on the spot. And yet the company did not want to take responsibility for it. And we would have not known about this accident had the German journalist not been there. The beaching pollutes, as Marco said, as Julia said, and here are some of the findings of different reports, EU audits, Indian national reports as well, that have identified levels of pollution way above the national authorized thresholds. These reports are available online, so you can also go and find them. And solutions do exist, and here are some of them. There is a picture from Norway, there is a picture from Bahrain, there is a picture from Kishhorn, UK, there is a picture of a Petrobras vessel, which is a company that has adopted a new policy to go off the beach and create capacity in Brazil to recycle vessels in a dry dock. And there is an outline of a new facility that is planned in Japan. And what is common with all these facilities is that none of them are happening on a tidal beach. They're all dry docks. And they're all happening in countries, ship-owning countries. So the countries that own the ships that are ending up on the beaches in South Asia, they don't do beaching. And when they're creating new facilities, they're creating new dry dock facilities to contain the many pollutants that are on the ship. And just to end off, going back to the offshore vessel, that was a ship that ended up in India, and the owner received almost $13 million for the vessel. They sold it via a scrap dealer known as a cash buyer to the beaches in India and got money for it. Right about at the same time, there was another asset, another FSO owned by Shell that was recycled in Norway in a facility there. Both of these units contained NORM, naturally occurring radioactive materials, which are quite complicated to remove from these structures because it lays itself as scale in the pipelines, and it is extremely toxic to manage. So you need to there's a lot of precaution necessary to do it in the right way. But whilst BW Offshore earned 12 million, almost $13 million on selling the ship, Shell probably paid $20-30 million in managing the hazardous materials correctly and recycling the vessel in Norway. And there's a really good video on YouTube where you can see the dismantling of the Shell Curlew vessel being taken apart. And this kind of crushes one of the arguments that the price differences between these regions is based only on different labor costs, etc. You don't have a difference of labor costs of $40 million US. This is a result of not managing hazardous materials such as mercury, such as NORM in a proper way at the beaching facilities. Thank you.
Thank you, Ingvild. Next, we're going to try to bring Maria online here. One of the unequivalencies, one of the reasons why these two conventions we're talking about today are not equivalent is that there's actually criminal accountability in the Basel Convention. Hong Kong does not have criminal accountability. We're going to speak next to Maria Bakkedal, public prosecutor, National Authority for Investigation and Prosecution of Economic and Environmental Crime from Norway. Thank you, Maria. Oh, you're muted.
Thank you for having me on. Can you see my presentation on the screens?
We can.
You can't, or you can? Ah, there it is. Okay, so I have been asked to present our work on the successful criminal prosecution based on the Basel Convention. We have worked with a few ship recycling cases, beaching cases, and they have all been based on Basel Convention rules. And the main case that I would like to talk about today is the so-called Harrier case. And Harrier was one of several names for a specific ship that was destined for recycling in Pakistan in the beginning of 2017. Can I have next slide, please? And here you see the ship on this picture. It was a so-called lash barge carrier built in Ukraine in 1989 with a light displacement. Oh, yeah, we can, that's okay. With a light displacement of 21,000 tons. And this ship was acquired by a Norwegian ship owner in 2017. And as it happens, the Norwegian ship owner, he never found commercial use for the ship, and he kept the ship in layup, warm layup and cold layup for the whole period of his ownership from 2007 until 2017. And he had a lot of financial difficulties, and after several years, he was eventually forced to sell the ship. And then he chose to sell to a subsidiary of the well-known cash buyer Virana. And in late 2016 and the beginning of 2017, Virana crew flew to Norway and started to prepare for sailing off the ship. And this preparational work included a marine warranty inspection, reparations, a new insurance policy, a new flag. They changed from Panama to Comoros, and also a new classification society from DNV to Union Marine Classification Society. And then, as you can see on the slide, Cash Buyer crew embarked on the ship in Norway and started sailing towards Pakistan in February 2017. And then I would like to have the next slide. A few days after departure, the ship had a complete engine failure off the west coast of Norway, and the ship then started to drift towards the beaches of Jæren. And this is agricultural area, but also an environmental protected area, as it is an important place for bird migration. And the engine failure was, of course, discovered, and Norwegian authorities initiated a salvage operation, and thus prevented a major oil spill, as the tanks of this ship were neither drained or cleaned. And the salvage operation was also the main reason that Norwegian authorities that the illegal waste export was brought to the attention of Norwegian authorities, as it is safe to assume that without this marine incident, the ship would have sailed out of Norwegian territorial waters and proceeded to the beaches of Gadani in Pakistan. And next slide, please. But the salvage operation also brought Norwegian authorities in position to have the ship arrested and issue a sailing ban on the ship. And eventually the ship ended up being recycled at a facility in Turkey. But while in Norway, the Norwegian police was able to employ certain coercive measures. Most importantly, we managed to have computers of the crew seized to secure evidence. And furthermore, also very important was that we managed to have a Norwegian court order a security deposit of 12 million Norwegian crowns, equaling 1.2 billion euros. And this the security deposit was to secure the future payment of any fine or compensation that the company were deemed to pay. And the ship was not released from Norwegian custody until the security was deposited. Next slide, please. And the criminal proceedings firstly resulted in a fine issued to this cash buyer company, Virana, of 7 million Norwegian crowns. Not the highest of fines, considering the line of business we are dealing with. But the sale-off was considered an attempted illegal waste export under the EU waste shipment regulation, as implemented into Norwegian law. And a major question in this part of the case was whether the ship was destined for recycling Pakistan or not. Virana claimed that the ship was to be employed off the coast of Africa and presented Norwegian authorities with both a bareboat charter party and a dry dock reservation to document the future use for this ship. However, the police investigation uncovered that this was a straight-up cover story designed to trick Norwegian authorities into releasing the ship. and there were an abundance of evidence pointing towards a final journey to the beaches of Gadani and scrapping. And the investigation really left no doubt concerning the true intention of Virana. And examples of evidence are a voyage plan to Gadani, insurance papers in 2 versions, both to Gadani and to Africa, and internal emails discussing Gadani as a final destination. And this fine issued by Norwegian police was not challenged in court, and it was settled by using parts of the amount that had been deposited as security. And in this way, the Norwegian police avoided a potential showstopper for the prosecution of Virana, as it would have been very difficult or nearly impossible to bring about court hearings in Norway towards the Singapore-based company Virana. And there would also have been tremendous difficulties in having the fine enforced in Singapore in a situation without the deposited security. So this was a key element of the successful prosecutions towards Virana. And this highlights a challenge that I assume is common in beaching cases, as the owner company and the management company often is based in a flag state jurisdiction far away from law enforcing authorities, and also in jurisdictions with weak traditions for international judicial cooperation in criminal cases. But in this case, we succeeded in having the fine actually enforced towards Virana. There was a second part of this case, if you can turn to the next slide. We also brought proceedings against a Norwegian individual. This part of the investigation and case resulted in an indictment towards the previous ship owner in Norway. He was indicted for abetting and aiding the illegal waste export and facilitating in effect Virana's sail off from Norway. And he was found guilty in court in the first instance hearing and also in the appellate court, and sentenced to 6 months imprisonment. And also important to note is that the registered owner company of this ship, before it was sold to Virana, had 2 million Norwegian crowns confiscated. This was deemed the proceeds of selling to Virana rather than to an approved recycling facility. And we can turn to the next slide, please. Well, as you are well aware of, a criminal responsibility for individuals and companies must, of course, be based on a proper legal basis on the national level. And I have put in a reference here to Article 7 of the Convention of the Protection of Human Rights. And as you know, the Basel Convention, of course, mandates that the convention parties take the necessary steps in their homely jurisdictions to be able to punish as a criminal offense any breach of the Basel Convention. And in Norway, this criminal liability is mandated in the Norwegian Pollution Control Act. And this legal instrument both implements the waste shipment regulation as is into Norwegian law. This is a necessity, as Norway is not an EU member. We have to implement all EU legal instruments. And this Pollution Control Act also mandates the criminal liability. And as you can see on the slide, illegal waste exports are punished with fines or imprisonment up to 2 years. And the next slide, please. One point to note is that the Norwegian Pollution Control Act's geographical jurisdiction is limited to waste within Norwegian territory. And this means that if a ship has become waste in accordance with applicable rules just outside Norwegian territorial waters, Norwegian authorities will not have jurisdiction to punish any violation of the Basel Convention. And this, of course, constitutes also a real challenge in regards to ship recycling cases, as ships by nature will move around the world and might be more or less coincidental if a ship was inside Norwegian borders at the relevant time or outside. And even if Norway has one of the world's largest commercial fleets, a big share of this fleet will never sail in Norwegian waters. And this relates, of course, to the question state of export, as highlighted already by Mr. Orellana. And this challenge manifested itself in the next case that I would like to shortly mention. If you can see the next slide. We call it the shuttle tanker case. It concerned a ship that you can see on this picture here. And also another shuttle tanker. It actually concerned 2 shuttle tankers retiring from the oil industry in the North Sea. They were consequently sent to India for scrapping. Next slide, please. And these 2 ships, they were both managed by a Norwegian-based management company and with foreign ownership of both vessels and of the management company also. And as the ships reached neared the commercial limit of operation in the North Sea of 20 years, the management company tried to find alternative occupation for the 2 ships, but they both ended up recycled in Alang. This was in the period of 2018 until 2020. And the formal decision to scrap the ships by the registered owner not in Norway. I can't remember the exact jurisdiction of the registered owner company, but the formal decision in these companies were taken long after the ship had sailed from Norway, and this we assume was a deliberate decision to delay the formal decision to scrap the ships until after the ships had sailed out of Norway. But during the investigation, the management company asserted that at the time the ships left Norwegian waters, it was still undecided what they wanted to do with the ships. The profitable alternative was, of course, to use the ships on new contracts elsewhere than the North Sea, but this showed very difficult. And in deciding the case, we concluded that the ship must be deemed waste, even if the formal scrapping decisions had been made after the ships left Norway. And both in the Basel Convention and in the EU's waste treatment regulation, waste is, of course, defined as objects that are discarded, but also objects that are intended to be discarded. And in our assessment, we considered, amongst other factors, the market outlook for this kind of ships, the company's history with lack of success for alternative employment for these old ships, and also the actual preparational work the company had done to prepare for recycling on these 2 ships. And the investigation ended with us issuing a fine of 8 million Norwegian crowns for illegal export of these 2 ships. And initially the company refused responsibility, and a court hearing was scheduled to January this year. But as it happens, only a few weeks before the scheduled court hearing, the company decided to change its position and accepted a fine. So we did not have a court hearing in this case either. And to the last slide. Is there another slide, perhaps? There is the, yeah. So this was the last slide I meant to present it to you today. In conclusion, we consider these beaching cases or ship recycling cases as serious environmental crime, economically motivated. And Norwegian police has, at least in the past, been eager to give priority to these kind of cases. One important point to note is that the cases have received a fair share of media coverage. And this is, we consider this very important to make the industry aware of the risk of criminal prosecutions. And it is our impression that the attention of the cases have resulted in much more diligent recycling strategies by ship owners and management in Norway, as the risk of reputation impact weighs quite heavily on these companies, especially the more serious part of the business. So with that, I conclude my presentation.
Thank you, Maria. Thank you very much. And we'll online. Okay. The reason we're having this site event this week is because the Hong Kong Convention, which has been gathering ratifications and sitting idle for 14 years, is about to enter into force. And the other day at the IMO, which is the mothership of this convention, they created a decision. Basically said, if you are a party to both the Basel Convention and the Hong Kong Convention, we would like you to consider only applying the Hong Kong Convention. Basel parties are basically asked to consider standing down and not fulfilling their Basel Convention obligations. So we hired a lawyer, and we have a lawyer with us here that is going to elucidate on the arguments that have been brought forward by the IMO and our expert lawyer, Professor James Harrison from University of Edinburgh, about this question. So David, take it away.
Thanks a lot, Jim. Thanks, everyone. First of all, to clarify, I'm not the expert lawyer that this. Yet there are a couple of legal questions that have been asked about the coexistence of those two conventions that I have also worked on and published on in the past. But a lot of things have been said already by Marcos, by Jim, by various presenters. So I'll try to go quick and light and easy on much of the legal arguments, still putting them forward for you to consider, and try to look beyond and look forward. So again, as Jim was mentioning, why are we here? As Jim and other presenters shown, why are we here? We've heard how appalling the existing ship recycling practices are, what they entail in terms of health, environment, and human rights violation. We've heard and we've seen pretty clearly how the Basel Convention, however imperfect it is, can provide some elements and some support to address these wrongs, and how the Hong Kong Convention, while it was designed or purported to address some of those issues, do not. We've seen what the Hong Kong Convention yards continue to look like. So again, why are we here? Because of economic reasons. Because of economic reasons, some operators are trying to want to simplify things. And we know what simplifying things mean in these particular cases. Simplifying things mean doing away with environmental, health, and human rights protection, and with actual laws and international obligations, because there are actual international obligations that exist and should be implemented. And one of the way they've been trying to do this is to put forward a couple of arguments to do exactly what Jim just described, to say, well, the Basel Convention doesn't really apply. And the two main arguments that have been put forward so far are, one, there's a conflict between the Hong Kong Convention and Basel Convention. And if you try to resolve this conflict applying international law principles, then it should lead you to apply the Hong Kong Convention. Well, first, we want to make it very clear, and Marcos mentioned at the beginning, is that divergences and different obligations does not mean conflict. And the conflict is when it's impossible to comply with two treaties at the same time. And this is not the case in this particular instance, in part because both treaties establish minimum requirements, and you can always implement both treaties by implementing the requirements that are the most stringent. So there is no real conflict. And again, as was also highlighted by the International Law Commission in a study on the fragmentation of international law, the Law Commission clearly stated, states bound by treaty obligation should try to implement them as far as possible with the view of mutual accommodation and in accordance with the principle of harmonization. So these are the principles that should guide how we view those two treaties. And those two treaties can coexist, and there is no conflict. Now, assuming that there would be a conflict, how should those conflicts be resolved? Would one treaty supersede the other? Again, Marcos mentioned at the very beginning that this is not a purely hypothetical case, in the sense that both the Hong Kong Convention and the Basel Convention actually provide for answers of what should happen if a conflict arose. And both make it very clear that, the Hong Kong Convention that was adopted after the entry into force of the Basel Convention, first of all, recognizes the existence of the Basel Convention and recognizes that this convention, the Hong Kong Convention, was adopted without prejudice to existing obligation. So the parties, when negotiating and adopting the Hong Kong Convention, made it clear that there was no conflict and that the Hong Kong Convention principles should not be considered as superseding or eliminating the need to implement the Basel Convention. So that's for one of the arguments that were raised. The second arguments that were raised was, well, in fact, there is no conflict, but they're equivalent. And because they're equivalent, the Hong Kong Convention qualifies as an Article 11 agreement under the Basel Convention, and thus the obligation from the Basel Convention don't need to be implemented. After the presentation that we've heard before, I don't know how much in detail I should even go into explaining why a prior informed consent and total ban of export cannot be equated or cannot be considered equivalent to the export to some of the facilities that we've seen before. There were a number of legal studies that were provided that demonstrated the non-equivalence of the Hong Kong Convention with the Basel Convention, and that was even prior to the entry into force of the Basel Ban Amendment, that strictly and basically bans the exports of hazardous waste to non-OECD countries, to non-OECD countries. With that having entered into force, there is no way to claim that a mere looking at a facility and certifying a facility as being okay, such as the facilities that we've seen before, could be considered an equivalent level of protection as an actual ban to Global South countries. All right, so I think the legal case is extremely clear. Yet, of course, while lawyers like to have very clear cases, we're not only obtuse, we're also obtuse sometimes, but we also recognize that the fact that the legal case is clear doesn't mean that there is no burden. The fact there's no conflict doesn't mean that it doesn't that some complexity exists on how you make those two conventions coexist and how you can continue to have them implemented and enforced at the same time. And so here are the few, I just want to finish with a few suggestions of how the parties to the Basel Conventions, how you should basically think of what are the way forwards to actually simplify and facilitate the coexistence of those two conventions without abandoning all pretenses of environmental, health, or human rights protection. So the first thing that should be done clearly is reject the ILO provisional guidance that the IMO, yeah, I'm sorry. Not reject the ILO guidance. But the parties should reject the IMO guidances, not only because of its content that is inaccurate from legal basis that just explained, but also because it is not for IMO parties to decide how to implement the Basel Convention. It is up to Basel parties to actually decide how to implement and interpret their own convention. So on that very first basis, that guidance should be straight out rejected. Now, there is the COP decision that is in front of you and that is actually being discussed, that will be discussed very soon in the contact group, proposes or invites parties to comment on the IMO decision. But again, because the IMO should not be the one setting the frame in how this is discussed, we believe that it would be important for the parties here, as was proposed by a country, to not only comment on the IMO guidance, but also be able to provide suggestions and other elements on how those two conventions could coexist. Again, because it is up to the Basel Conventions to decide how it should be implemented, it should not limit itself to commenting on what other parties to another convention have been saying, but also be able to propose ways how to implement the Basel Conventions. And among those possibilities that should be discussed, we believe, or that should be proposed and at the very least discussed, are ideas to, first of all, undertake a new assessment of equivalency, and that should start with defining terms of references for what equivalency is for Article 11 conventions under Basel. And that would actually go beyond the question of the Basel and Hong Kong Convention. This is a topic that is becoming more and more relevant in a lot of other areas, whether it's about plastic and some agreements that are being concluded elsewhere as well. But beyond that, and recognizing some of the existing loopholes or challenges with implementing the Basel Convention, the Basel Convention could provide a better definition of what the exporting state is with regard to ships, and in particular, specify or identify that the beneficiary owner state should be considered the actual exporter, because the beneficiary owner states basically were the headquarters of the companies that own the ships. This is where the decisions to scrap the ships are being taken. And so this is how the beneficial owner state could be considered as the state of the defining export. And that would simplify a lot of things. It would clarify how it is imported, and it would facilitate the role of enforcement authority, as we saw just before from the Norwegian cases. Another element that the Basel Convention could do to facilitate the coexistence and clarify the coexistence is to provide clarity on when the intent to dispose a ship is actually being materialized. And we heard in the case that was presented some before, that can be manipulated, but just providing guidance and providing clear guidance on when the intent to dispose is being materialized could very much clarify how those two conventions actually coexist and live together. These are just some elements that we put forward for consideration, but also just to highlight that, again, it is up to you as Basel parties to decide how the Basel Convention should implement and should apply to ships having been already defined and considered as hazardous waste under the Basel Convention. Thank you very much.
Thank you, David. Right now, last part of our presentation, I have a very special guest, and I'm going to introduce you to her. And as soon as I move these chairs inward, we're going to have a little fireside chat here. I'm going to interview our special guest. So the party that David referred to as having proposed an amendment to the draft decision in the room across the hall here that they're talking about this was Bangladesh. And it's my great pleasure and honor to be joined tonight by Rizwana Hassan, who is the advisor of the Ministry of Environment and Forests and Climate Change in Bangladesh. She's called the advisor at the moment because it's an interim government, but it's my understanding that's the equivalent to being the interim Minister of Environment. Rizwana, I'm really pleased to talk to you about these issues because us on this panel so far, we've been advocates, we're experts, we have a very strong point of view. Not being government ourselves, we don't have to have this difficult balancing act between economy, employment, labor rights, environment, politics, etc. So it's great to have you here with having to think about all those things in governing a country that happens to be one of the leading shipbreaking countries in the world. So I'm going to ask you some questions, and after that, we're going to open it up to the audience, and people can ask Rizwana any questions as well as the panel. So
you can ask me questions, easy ones.
they're so easy. You just no. We'll see. So first question, many at the IMO and some national proponents of the Hong Kong Convention, such as Japan and Norway, paint a picture of vast improvement in compliance at the shipbreaking yards on Chattogram in Bangladesh. Do you believe that the situation in Bangladesh has improved to the point that workers are no longer suffering labor and human rights violations and the environmental harm is now minimal?
I doubt. I do not think there has been a significant and meaningful improvement. Yes, certain yards have improved their facilities, but they're still operating on the beaches. And the country lacks a final disposal facility. So of course, those who are involved in the business will show their excitement around Hong Kong Convention. But as someone who has worked on this industry and who has taken this industry to court several times, I still follow what's happening there. And it was few months back after I took over office, there was a fire in one of the Hong Kong certified yards that actually have burnt 12 people, and 6 of them have eventually died. So that is very clearly telling you about the protection that the Hong Kong certified yards will actually be giving to the laborers. And in addition, other than this 7 yards that have got Hong Kong compliance certificate, there will be other yards who will continue with business as usual, and they'll be dismantling the vessels under the sky, on the beach, in the open, without any containment facility whatsoever. So while Hong Kong will have its application on the 7 that have been certified by it, others will still be continuing in the same way. And yes, was it yesterday? Yesterday was 1st of May, and some of the Bangladesh's leading newspapers have actually come out with stories on how laborers are still being exploited in the shipbreaking yards in Bangladesh. And the official statistics say that in 10 years, 135 laborers have died and 200 have been grievously injured, while there are many whom no one has counted who are suffering from occupational hazards, including asbestos-related hazards. So, and my last point on this question would be, the yards that are being certified as Hong Kong compliant and that are being strongly advocated by some developed countries, the same yards with the same standards will not be accepted by their national governments. So yards that are being certified there in Bangladesh as being compliant, the same yards with the same standards will never be certified in any Western country. So yes, you will get a certificate, you will get a green document, you will get some degree of legalization. But I don't think that will satisfy the environmental justice advocates or the human rights advocates.
Second question. What is the view of Bangladesh about its shipbreaking industry from an economic point of view? Is its presence a net positive economically for the country on balance? Or is it a net negative given all of the hidden externalized costs of human health, environment, and other impacts?
Two aspects here. There are economic arguments in favor of the industry. And the economic arguments from the standpoint of Bangladesh is purely national, that we need steel and it employs around 20,000 people. But there are safer alternatives to both. There are years, there are months when Bangladesh does not import vessels because the price of steel goes up and the shipbreakers do not consider it profitable. So they stop importing vessels. There are years when we have imported less than 50 vessels. Does not mean that the steel industry has shut down. And the steel that comes from the ships, the old ships, are not of very high standard. Unemployment, I do not know if you call it employment or not. And people have seen pictures and they're real life pictures and they're real. And I would rather be comfortable calling it exploitation, because not to talk about Hong Kong or ILO, they're not compliant even with the national labor laws of Bangladesh. It is not a mainstream industry. Very few people are engaged in it. General people only get to hear about shipbreaking only when there is a massive accident that kills a few people. And when you talk about how important is it from an economic viewpoint, I would say that Bangladesh has alternatives to offer. And the shipbreakers themselves have shown it to the country when they stop importing vessels. One point that comes to my mind on this question, Jim, is that Bangladesh also is an exporting country. For example, it exports garments. When it comes to exporting garments, we have to be really compliant with this, with the international standards, because otherwise the buyers will not take out. But when we get into the role of importer and we import these toxic vessels, the same conditions are not asked from us by the Western countries. So that shows that they're actually not following one standard for all countries, and that's worrying. The reason is it's people's life you're talking about. It's mercury contamination, it's asbestos contamination, it's lead contamination you're talking about. So how can you have different standards for the people of Scandinavia and the people of Bangladesh?
Thank you. So Bangladesh has ratified both Basel Convention and the Hong Kong Convention. Was it the intent of Bangladesh upon ratifying the Hong Kong Convention that you would cease to apply the Basel Convention for ships?
I think the position of the government of Bangladesh is pretty clear. And we have accepted Hong Kong as a reality, but we have been very clear in stating that we would go for dual competency, because Basel has given legal coverage to certain political positions, like developed countries can't be sending their toxic tourists to developing countries or poor countries in the name of business. That legal coverage I don't really see there in Hong Kong. And I think Maria, David, and Marcus have elaborated on that. Bangladesh would definitely stick to its Basel commitments about the responsibility of the polluters. It would definitely like to see its territory being protected against dumping. And it would definitely call for the ship owners who have benefited from the commercial life of the ship to take on responsibility of dismantling of their toxic land vessels.
So you think it's possible, you've looked at both conventions, to apply them at the same time, or would that be, create so much inconvenience and friction to basically ensure the industry will not bring value to the country?
That is yet to be seen because Hong Kong hasn't entered into force and the Bangladesh legal regime is not prepared to really follow the Hong Kong prescribed procedure. On the other hand, we have got series of court judgments where the court has relied on Basel and has required the Ministry of Environment to frame rules following the Basel procedure. So I fear that there will be, there will be need for getting clarification on things, but on waste issue, on the transboundary movement of waste issue, on the issue of the liability of the owners, cash buyers, the requirement of decontamination, I think Basel will very much remain valid.
Thank you, Rizwana. Is there anything else you'd like to add to the discussion before opening it up to the audience?
One thing that really concerns me is the reluctance in the international community about addressing the issue of flag of convenience, because we do have the EU regulations, and I thank the EU community for coming forward to kind of give approval of this problem and trying to address it. But the legal regime that we have in hand, both internationally and locally, do not address the flag of convenience issues. So even with Hong Kong fully in force, even with Basel in force and the European Union regulation in force, vessels are entering Bangladesh carrying the flags of the tax haven countries. And that is a major issue because we can't get the cash buyers to hook. We can't really put them to any degree of accountability. So they produce unreliable certification on waste, and on the basis of those unreliable certificates, our agencies are allowing vessels to enter. The laborers, as you have heard, are not ever informed about the risk they're exposed to. So I think on the international legal arena, this is an area of concern. And that was the whole reason as to why Basel decided to bring in IMO to exercise its authority, because ship is not particularly Basel's expertise, waste is. But on that count, I think Hong Kong has not really succeeded to ensure that the ship owners play a fair game.
Thank you so much. Now, I'd love to hear any questions you all might have for Rizwana or any of the panelists. You got a question? Comment? Do we have any online?
Only work from the presentation.
Is that wonderful? Yeah.
Sorry, I had a comment for my English note. No, it's good. I speak English a very little. I'm from Panama, and I go last year in the Canal Panama. My goal is before the ship for the canal, we
Excuse me, would you prefer to speak Spanish and Marcos can?
you can okay. Oh, good.
Happy to translate.
Okay. Yo trabajé muchos años en el canal de Panamá haciendo epidemiología. Antes que los barcos crucen el canal de Panamá, hay que inspeccionarlos si no tienen ningún problema ambiental.
So she worked many years at the Panama Canal doing epidemiology. So before a ship crosses the canal, there are inspections that take place.
Ya. Y me llamó la atención que dicen que comercialmente los barcos solamente tienen de vida 20 años.
So she's struck by the assertion that commercially certain vessels only have a useful lifespan of 20 years.
Y vi muchos barcos con más de 20 años en muy buenas condiciones.
She has seen many ships with more than 20 years in good shape.
Habría de tener algún tipo de normativa porque es como un carro, ¿no? Y eso estamos hablando de barcos enormes. Y saben que Panamá también tiene uno de los países con mayor abanderamiento de ¿cómo se llama? De fronteras de nacionalidad. Ese era el comentario. Pues, me llama mucho la atención el tiempo de vida que tiene el barco que comercialmente 20 años.
So she suggests that there could
Gracias.
be rules on the matter of lifespan because, like cars, some vessels can live for a long time in good shape. And she also refers to Panama being a country with a large volume of tonnage and its nationality.
Thank you. Any more questions? Yes.
I have one question. I'm new to the subject, so probably say something wrong. I'm from Cyprus, and even though we're a small island, we have a lot of ship management companies and registered ships. But we're discussing one issue about reflagging, like 3-6 months, a year maybe before the end of life of the ship, they change the flag of the ship, and then you lose flag and it end up so in illegal graveyards. How is there any mechanism that we can combat this issue?
I mean, when we've done a lot of analysis and we have a lot of data on our website as well on end-of-life vessels that have been scrapped globally over the many years, and we've been trying also to identify when the change of flag happens and what it's related to, and it's related to primarily the sale of a vessel to a scrap dealer. These companies known as cash buyers. And so, I mean, there is flag registries can conduct some kind of due diligence in the terms of looking at which companies are asking the change of the flag. And in the data that we have collected, there are also certain flags that are very popular at end of life, but are not popular during operational life. So there are some indications of the reason why the vessel is changing flag, and good questions that can be asked by flag registries to stop it.
The age of the ship.
And the age of the ship.
If I can add something to this as well, as in order to ensure something that wouldn't change the practice, that would ensure that even with this practice, better accountability is provided at the end of life, would be to for Basel to clarify who is the exporter, and to ensure that the responsibility for the end of life of the ship rests for the export of the ship as waste rests with the country where the headquarters of the ship owner is. And so whatever flag is actually flown by the ship, where the ship owner is established, and where the company that takes the decision of scrapping the ship and send it for scrapping or recycling, then this would be the country that has to provide prior informed notification to the importing countries, and that would create a better accountability and greater transparency and visibility. And that is one of the issues, one of the things that Basel Convention could actually do as Basel parties and could decide to implement to clarify the coexistence, both to clarify the coexistence of the convention and address some of the remaining issues in the industry.
And just to add on to what David said, selling to a scrap dealer is a manifest intent to dispose, right?
Any more questions? You.
Yes. Thank you, Jim. Thanks, Rizwana. Thanks all the speakers. It's interesting to have that kind of what you call it, the IMO of countries or parties allowed to consider whether they are going to stand down of the Hong Kong Convention or implement both. But for some countries, I believe it's very convenient to pick only Hong Kong. But the party to Basel has to apply both. And we have several cases in the past, like JNAT case, yes, where they have this contaminated FSO sent to Bangladesh and Alan, I can't remember which one, still have mercury contaminated tank or aerosol. Oh, how these kind of things can be prevented if countries only applied Hong Kong and not applying Basel? And what kind of regulations that we should advise our countries to adopt both and not taking the easiest one? Thank you.
First of all, if countries are parties to both Basel and Hong Kong, in the present legal situation, it is actually illegal to only implement Hong Kong, because they are parties and they have obligation under the Basel Convention. And up and until the Basel Convention decides to step down collectively, parties are bound by their international obligation as parties to the Basel Convention. And so that's the legal situation. So the recommendation is that in order, if they want to comply with their international obligations, they have to look at how they can implement both, but they cannot choose just one. And this is what the IMO is trying to do, is trying to say to countries, it's okay, you can do this. And this is what they're trying to do with their proposed guidance. And they've put that forward for the parties to the Basel Convention to say, look, we've sorted out for you. You just have to look the other way and stand down. But that is not a correct legal interpretation. The only way it would become a legal interpretation is if the Basel parties decide collectively to stand down, which we believe they absolutely should not.
Any more questions?
Jim?
Yes.
There's one more question there, one more hand there.
One more question. After. Yes.
Yes, Beat from Norwegian Environment Agency. This is actually not a question, but I think we have not succeed in every way, but we have had some court cases that Maria showed us. I think what we have done that have been successful is to have the cooperation between the maritime authorities, like the flag state authorities, and also the environmental authorities. About the marine authorities, and we also use the Norwegian Coast Guard to help us to prevent illegal ship recycling.
Yes. Can I ask you a question?
Yes, of course. I'm not sure if I will answer, but
so it sounds like Norway intends to implement both.
we have.
And you're going to continue to implement both.
Yes.
So Norway doesn't agree necessarily with the proposal by the IMO.
I don't know if you heard Norwegian position, but it has been announced that we follow the Secretariat's position.
I'm sorry, can you
We
speak?
follow the Secretariat's advice, the Basel Secretary's advice.
Okay,
Yeah.
so you're not sure yet.
No.
Thank you so much for that. And did you have a question?
I do have a question for Maria Bakidau from Norway, if she's listening to us. Yeah, thank you for your presentation. As I understood, you to very clearly articulate that prosecutions took place under Norwegian law internal Norwegian law. And one of the limitations of that body of law is that they refer to waste that is found in Norwegian territory. Or under its jurisdiction, possibly, but I need to get into that detail. The question is whether Norwegian law could be amended to encompass a broader reach and actually deal with the point that David has articulated on the beneficial owner of the waste in order to precisely control the decisions that are being taken in Norwegian territory, but in respect of waste not found in Norwegian territory. If you feel that such legal change is possible, leaving aside the issue of political will, whether in Norwegian constitutional law such a legal change could be possible. And if it is possible, then perhaps you can speak as to your opinion as to what are the challenges or the obstacles in getting there. Thank you.
Thank you for this question. I'm not quite sure if I'm the right person to answer whether it will be possible to amend the Norwegian Pollution Control Act to encompass also waste outside Norwegian borders, or intentions are already covered by Norwegian law. Maybe Beate from the Environmental Agency is in a better position to answer this question. But one point to note is that, of course, this Norwegian law applies to all kinds of wastes, not only ships, and ships could be considered a special kind of waste, as ships will normally move across borders to a much greater extent than waste usually will do. So I think it's a difficult and long way to go to amend the Norwegian legislation along the lines that you are proposing. Especially in the respect that this is supposed to cover all forms of waste. Maybe Beate would like to speak on this difficult question.
I could try, at least I can say something about it. What we see in these court cases, that is difficult when the waste, as the ship in this case, is abroad, and also the owner is in Norway, but the ship has never been to Norway, or it has been just in Norway for just some years ago. So we know that it's a challenge, it's a loophole, and we look into it, but I can't promise anything if it will get into Norwegian law or if it will be. So, but I think it's good that we have kind of pointed it out that this is an issue that we should dive into.
And of course, if Basel were to solve that loophole with the work they could do, then it'll apply to everyone, and that would be a huge step forward. And it's important to note that both conventions have loopholes. The Flags of Conventions is a massive loophole. You're going to put the implementation of a convention on flags of convenience, which are formed to be unaccountable and to fly outside the rule of law. That's not asking for really solid basis for a convention. So there's work to be done to bring these two together, close the loopholes on both sides, and find out the best way to make this happen. Any more questions?
No, just to add what these loopholes are, basically. We wrote this Basel amendment, that who can also try to highlight the difference between Hong Kong and Basel amendment. I want to clear my doubt, Hong Kong is more about safe recycling and, but Basel is more about transboundary movement. So fundamentally there is some difference I see, but when we are talking about synergy, like after Bangladesh, I know that they don't have the TSDF facility, So I don't know where these waste are going for, the recycling and other things. So after this Hong Kong Convention, Basel starts. So I believe. So can you give some clarity on that?
You want to take that one? Well, some people at the IMO are saying, oh, we're going to work with Basel. Basel's going to take care of everything after we've done the transboundary movement and after we've had the facility. So the downstream waste, we'll give that back to the Basel Convention. Well, that's the trickiest part of the whole thing. And A, but B, the Basel Convention, if you look at the title of it, it's about controlling transboundary movement. That's our thing. That's what we do in Basel. And the environmentally sound management is just part of that, but it doesn't have really legally binding criminality and et cetera. It's not what the convention was meant to do. It says, of course, you have to be ESM and we can give you guidelines on how to do that. But there's really no legal accountability for the downstream part of Basel. What we're focused on is doing things right by developing countries, not having to bear a disproportionate burden from all the toxicity on the world's ships, which is what's happening. Developing countries are getting a disproportionate burden, massive burden on these 3 beaches, basically. And that's what Basel was there to address. Hong Kong did not want to address that. That's why, in my opinion, Hong Kong exists. It was not to solve problems, it was to run away from people that were really trying to solve problems. So it's my last sermon of the night. Anybody else wants to comment? Yeah, you.
Sorry, 2 more questions. One is for Ingvild. So from the ship recycling lab, is it ship recycling lab, right? Is there any matchmaking initiatives to give to have investment match with the muchly needed infrastructures, for instance, in Bangladesh? That is one. And then second is for Jim. You have experience with e-certification, right, for e-waste. Is it going to be doable with ship recycling?
Wow. Certifications can be gamed. It's an industry that relies on audits. And the audits are only good while you're there. And if somebody really wants to cheat, they can cheat the audits. And that's our experience. So we've had to add layers onto the audit programs so that the administrator, whether it's the Basel Convention in this case or countries, they need to back up the audits by going in and do spot checks and make sure they're honest. But that's our bottom line after having experience with making our own certification on electronic waste. We now have to add to the audits by unannounced inspections, putting GPS trackers into the streams to see where the stuff really goes. So if you back them up, they're valuable. If people know that, wow, we could be checked, then they're valuable. The other question you had, I want to ask to Rizwana, which is the question of, would you be interested in doing like dry docks in Chattagong?
That's not impossible. And there is a code directive on that if shipbreaking has to continue, it has to continue in dry docks only. But I haven't really seen any attempt from the shipbreaking industry to do it. And Bangladesh, one has to know, is a very land scarce country. And there are many people who depend on the marine resources than the number of people who earn their livelihood from the ship recycling. So the country has to really debate around the waste dumping nature of this industry, unless and until the ship owning countries come forward to say that they will take the responsibility of the management and handling of waste. I think Bangladesh would do good to take a cautious stand in promoting shipbreaking in any form whatsoever.
Okay, I think that might be a wrap. You can certainly ask us questions in the hallways, but we're going to get back into that contact group and see what kind of interesting things have happened since you've been here. Thank you so much.